And now please allow me to introduce our speakers for today. Dr. Aaron Deshaw is an award-winning lawyer from Portland, Oregon. He has individually and in cooperation with other law firms obtained settlements and verdicts for his clients in excess of $1 billion. He is the founder of Trial Guides and is the leading author in the U.S. on the subject of the computer assessment programs used by most auto insurance companies for evaluating personal injury claims. Presently, more than 90% of Aaron's cases involve traumatic brain injuries, and the remainder of his personal injury cases being catastrophic injuries such as quadriplegia, spinal cord injuries, amputation, and wrongful death cases. He has extensive experience doing jury trials on complex medical injury cases. John Romano is a partner at Romano Law Group. He is a civil trial advocate, board certified by the Florida Bar and the National Board of Advocacy and the American Board of Professional Liability Attorneys. He has successfully litigated to verdict in nearly every type of civil and criminal case, including those involving failure to diagnose cancer, product defects, drug and vaccine defect litigation, libel and slander, vehicular collisions, personal injury, murder, armed robbery, and wrongful denial of health insurance benefits. He lectures across America on trial advocacy in tort and criminal law, has authored 3 textbooks, and has published more than 100 articles in national publications or papers for national presentation. He is the editor of the Trial Guides book, Anatomy of a Personal Injury Lawsuit, now in its 4th edition. They both have more extensive biographies on our website, but for today, I'm going to go ahead and end my portion and turn it on over to them.
All right. Thanks, Jessica. So my name's Aaron. I'm the founder of Trial Guides, and I am really pleased to have the legendary John Romano with us today. And I don't get to do these very often just because of time, but John is a really special person. Him and his wife, I think, would be a highlight in pretty much any plaintiff lawyer's life if you get to ever meet them. I'm going to just cover a couple things here real quick that I think are important. Uh, his wife Nancy is a very supportive, amazing wife. I've met her a number of times. She's high on my list of people in the legal profession. Every time I get to go to a conference, I'd love to bump into them and have a chat whenever we can. They have 4 kids together, 2 of which are lawyers, Todd and Eric, and they work in the law firm with John. They're celebrating their 35th anniversary as a law firm this year. And he's got 4 other lawyers that work with him as well. They handle a huge variety of cases, and I think that's one standout. If you think about John, he's tried all kinds of different cases, and we're going to talk about that a little bit together. Some standouts: $53 million verdict in a defective auto case, $44.9 million verdict in a motorcycle paraplegia case, $28.5 million verdict in an assault case. $26 million in a trucking amputation case, and he's tried over 200 cases, which most of us are probably never going to be able to do, even me, trying as many as I do. So Trial Lawyers Hall of Fame, which he's certainly well deserved of, and speaks all over the country for pretty much every different organization you can think of: state, national, AAJ, National Trial Lawyers, and he's also very famous, particularly in the East Coast, for the FJA Workhorse Conference that he's run. And if anybody's been to that, it's probably the most rigorous CLE that you will ever go to. He works you day and night while you're there. And then he's got his own Connectionology conference series that's going on nationally as well. But he's a real joy to listen to, and you can always pick up something new. And so I want to hand the program over to him, and he's got a lot of advice on things you can do to improve yourself. But then I'm going to interview him after that, and we're going to cover even maybe more ground. So, John, I'll turn it over to you.
Oh, thank you, Aaron, and I thank you and appreciate you, Jessica, for that nice introduction. And Aaron, you and I go back many, many years, and we've had so many conversations about trial advocacy and the courtroom and teaching and CLE. So I am thrilled to be here with Aaron Deshaw, not only a great scientist, a great expert, a great teacher, and someone who has really taken the lead in the field of legal publishing to teach lawyers, but someone who is a magnificent courtroom lawyer. When you wrap all of that into one, you have the total package. So Aaron, you're amazing, and I love how you mentor so many people all around the country, and that's what is so needed and always will be needed. mentoring the younger lawyers, the newer lawyers, and then once we mentor them, they start mentoring us, and we become co-mentors for one another. So when I was speaking with Aaron, one of the thoughts was, what is it do you as a trial lawyer want? What do you need as what I call not just the Bible of litigation, trial, being a plaintiff lawyer, but it's a series of books, roughly 12 to 15, that to me, each is an absolute necessity in your practice. When we hire newer, younger lawyers coming on board, part of the package that we give them is a stack of these books. And I'm going to walk through some of these with you because it is these source or resource materials that really have a way of changing everything that you do, the way you do it, how you do it, when you do it, who you do it with, who you avoid. All right, so let's go through this. And when you're looking at a book and you feel, is this something that will help me genuinely in my practice? Be thinking about the substance of the author. In other words, ask yourself about that author. What does he or she bring to the table in terms of that lawyer's real knowledge, real experience? What has that lawyer been through? And that's where you're looking, okay, I want to grasp that. So here we go. Number one, you can't get enough of Keith Mitnik. Keith Mitnik is a spectacular lawyer, getting one verdict after another all over America and in all kinds of cases. Mandell, products, auto, the works. Book number one, Don't Eat the Bruises. Book number two, Deeper Cuts. When you get Keith's books, you don't just read them like a novel. You study them like you're preparing for an exam, and you have sticky notes in them, and you yellow highlight, and you take the blue pen and the orange pen and you mark things up. These books are not meant to remain in a pristine condition that you then throw back on the shelf. They're made to, I hate to say this, Aaron, but almost eat up and somewhat destroy so that it becomes your personal work of art. Another book, Case Framing and Advanced Case Framing by Mark Mandell. Let me just share a recent experience with you. First, we go back to my reading Mark Mandell's first book, Case Framing. And in that book, in one chapter, he discusses how you take witnesses and you put character halos around certain witnesses, and you plaster other witnesses with what are called character stain. Just this past year, 2025, I was in a 2-week jury trial. The husband of our injured wife was going to be a very important witness because there were some challenges with her testimony, with even putting her on the stand because she was so intimidated by all that was going on. So we knew that it would be important for him to bring into the courtroom an aura that he would be able to put around his wife so that the jury could see and feel this aura of them as a couple and not her out this way and him out this way. The direct examination of the husband, who, by the way, was roughly 37, 38 years old. But if you looked at him at first glance, you would have thought he was 15. He looked so young, like a ninth grade. He's on the stand. He states his name. When did you meet your wife? What month? What year? February of 2009. Before you met your wife, were you employed? Yes. How long had you been in the job where you were employed just before you met your wife? 8 years. Tell the jury the name of your employer. Proudly, sir, it was the United States Army. Were you ever deployed? 5 times. On each deployment, did these take you at all to areas overseas? He said, of course, that's when he thinks of a deployment, that's what he thinks of. Where? Iraq and Afghanistan. How many months was each tour? 13 months. Were you in combat? Daily. For how long? 13 months, 5 times. Did you volunteer to go back after your initial deployment? I did. And the second and the third and the fourth? Yeah, I did. The jury wanted to jump out and hug this kid. They loved him. Just with that. And that character halo that we learned from Mark Mandell becomes a halo that now surrounds his wife. Set that aside. In the defense case, they call private investigator who does what? You know what I'm going to say. He does surveillance video. So as we're trying the case, a young lawyer who is trying the case with me, and there was David Eldringham and his young partner, Jamie Smariglio. We had talked about it, and I said, Jamie, you want to take this witness? He said, yes, sir, I do. He's a former prosecutor, by the way, Jamie. And here's how the testimony goes. By the way, they did a direct examination. Then 91 minutes of video was shown, and then the cross. And yes, it's painful to sit through 91 minutes of surveillance. But there were no smoking guns. It was all, she's walking in a grocery store, walking in a park, and they're trying to use that to show she can do normal things. He says part of that video was of her apartment in a gated community, right? He goes, right. And you're taking it from within the gated community, right? Right. How in the world did you get into the gated community if you didn't have authority to be in there? I would wait until the car pulled up to the gate. I would tailgate them, and when the bar went up, I'd stay right on their tail, follow them in. Jamie says, so you're a trespasser. There was an objection, but we were permitted to say he was a trespasser. Jamie then says, I noticed a little while later that you're actually taking video footage into the window on the first floor, which appears to be a kitchen. Yeah, that's right. So you're actually taking video into the privacy of their home. Yes, I did that. And you have other video of the husband when he goes out to his car. So you're filming him separately. Yes. But is it true that the video that you're taking looking at the second floor, you're actually taking video of them up in the privacy of their bedroom? I did. So Jamie refers to him as a trespasser, a stalker, and someone who's participating in voyeurs. And that created some commotion in the courtroom. Before you went to work as an investigator doing surveillance, what did you do? He says, proudly, I was a journalist. And Jamie says, would you tell the jury the organizations for which you were a journalist. And he looks up, proud as can be, and he goes, the National Enquirer, the Globe, the Star. He now had a character stain. He's a trespasser, a stalker. There's voyeurism involved. He's taken photos and pictures up into their bedroom. And where did he get his training? From what we commonly refer to as publications that are scandal sheets. And you could see the reaction from the jurors was like, you got to be kidding me. Read Mark Mandell's books. It's about how to frame issues, how to frame witnesses. All right. Polarizing the Case by Rick Friedman. I read the book many years ago. I was getting ready to try a case in Philadelphia. It was the first gas fracking drilling case. And they, on the top of this mountain in the Pocono Mountains, they're doing gas fracking drilling. By the way, I had as co-counsel, a true rocket scientist, because when people say it ain't rocket science, gas fracking drilling is rocket science. And you need somebody who really knows the science of that. And through the drilling, 3 people, actually 6 kids who had all gone to high school together, and then the 3 ladies married the 3 men, and they all have kids, and they lived just a little ways down from where the drilling was taking place. They all built their homes together themselves. No architect, no contractor. They did it themselves. For one of the women, she had been diagnosed with PTSD because one day she has 2 of her children in a bathtub, and it's like a 4-year-old and a 6-year-old, and she goes, give me just a second. And she turns to just grab something, and when she turns back, this black, almost muck-like, is shooting out of the faucet, and in like 10 seconds, it was already all over the kids. And of course, she was terrified. She starts screaming, gets them out of there, can't clean them right away because the water is disgusting and filthy and polluted because she didn't know it at the time, but because of the drilling. In that case, it was so bad that one of the experts actually turned on the faucet in the kitchen and showed us how if you put a match or a lighter next to the water coming out of the faucet, a flame goes shooting up because of the gases that were coming out from underground. Mom was diagnosed with PTSD. They hired an expert at the University of Pennsylvania who said, I don't think she's got PTSD. I'm getting ready to take his deposition. And I had just read the trial guide's book, Polarizing the Case. And I remember thinking, God, that's kind of risky. Some of the things that are suggested by Rick, but I thought, I've got an idea that it might work in this sense. So when I'm taking this guy's deposition, drawing the line in the sand on one issue is all of the things that Mom has reported. Do you accept that she is telling the truth? Well, you know, he starts fudging. I said, let's look right into the camera and just say this. Is she a liar or not? Just tell the judge and jury, is she a liar or not? That I would never have done that had it not been for Rick Friedman teaching me how to do it in Polarizing the Case. And he goes, no. I believe what she says she believes. In other words, she believes she's being honest and truthful. I said, okay, let's go to the PTSD. She doesn't have PTSD. well, you agree she has this, this, that, and the other. He says yes, which were certain signs and symptoms, but he didn't want to make the diagnosis. I said, look, is there staging in PTSD similar to staging in cancer, like stage 1 cancer, stage 4 cancer? He says, not yet. But in the new DSM manual that's coming out in a few months, by the way, this goes back to around 2010 or 11 when this deposition took place. He says, there will be staging. I said, well, are you familiar with the staging? He goes, I'm on the committee. So yes. I go, okay. Are you a proponent of staging in PTSD? Yes. Well, if she has this symptom, that symptom, and these signs, and this, that, and the other, true, she is at a minimum, under your definition, stage 2 PTSD. And he says, she would be. Yes. All right. Because of polarizing the case, we get that concession, which means, even though stage 2, it means this. He's now committed to saying she does have PTSD, and now it's a matter of degree. I learned that from Rick Friedman. Okay? Get these books. And by the way, when I'm reading these books, there are many times I go, oh my goodness. And then I open up the computer and I add something to an outline because I know that I'm taking a deposition next week of some witness where I'm going to use what I've just learned. All right. Of course, Rules of the Road by Rick Friedman. It is just tremendous. Outlaw, Outlaw, AAJ. I will tell you there's a 2-set book. I was involved in it as the editor, but it's called Anatomy of the Personal Injury Lawsuit, 4th edition. I recommend that you get that. There are about 35 authors, 35 chapters, and it covers everything from intake to the steps you take in the first 24 hours of handling a personal injury case, all the way through discovery, trial, appeals, everything. Another one. There is a lawyer in Rogers, Arkansas, Sach. He is a phenom, and the work he's doing is just extraordinary. His book is Depositions Are Trial. And if you have an opportunity to get to a seminar and listen to Sach Oliver, I'm just telling you, he will change the way you practice the law. He will change your life. He is that dynamic and that inspirational. All right. The great, the one, the only, and the deadly serious Mark Kosieradzki, who I don't think he's ever been serious a day in his life. He wrote not only the first one, but then another one, and has spent a great deal of his career on 30B6 deposition. It's like a manual. It's like a, if you're taking it, if you buy some extraordinary toy that you have to put together for your 7-year-old boy or girl, and you open up the set of directions or instructions, you know you need to follow them, and then you're going to have this wonderful toy, and it'll bring great joy to your little boy or girl. Well, when you read the 30B6 book by the Kos, we call them, that's what it is. It is a manual on how to put it all together. But the one thing the Kos tells us is, you don't start thinking about a 30B6 depo 5 days or even a week before the depo. You start thinking about it 4 or 5 months, or maybe even more in a situation before the depo. And of course, nowadays, you have to get the notice all worked out in advance of the categories for the 30B6 designee, very important. And then you get ready. What the Kos does in the book, he gives you that roadmap. He shows you how to navigate the depo, what to do when they say this, what to do when they say that. Extraordinary tool. Another book, and it's loaded with motivation and inspiration. This book is by Carl Bettinger, 12 Heroes. It's the kind of book that you read, and when you're done, you think about it. And then you come back a month or two later, and you go back through different parts of the book. It is very instructional. It's a great teaching tool, but frankly, I found it far more inspirational, motivational. Nick Rowley's Running with the Bulls. You will get fired up when you read this book on how to take every step in the handling and litigation of a personal injury case. John Morgan, out of Orlando, Florida, but with offices, I think, in every state now. His first book, You Can't Teach Hungry. Every lawyer needs to read that and really understand it. And then he came out with a second book, You Can't Teach Vision. Same thing. And his brand new book, let me see here. I want to make sure that I give you the right name of the book. Thought I had it written down here. Life is Luck. And it starts out when John Morgan was a paper boy. And it walks you through his life and how he says, I got lucky with the lady I married. I got lucky with the kids I had. I got lucky with my law partners and running into Keith Mitnik and so many others and their children. And it's just is really such a fun and enjoyable book, but it's a great teaching tool for you. All right, there are more. The first time I got this book, I was still a JAG officer in the 70s in the United States Marine Corps. And they had come out with a special, I don't know, I'd call it more like a pamphlet than a book. But the book is called Evidentiary Foundations by Edward I. Imwinkelried. Imwinkelried. So when I go to court, I have one box that we take. I know any of the young lawyers take only devices. I still like to have my little box books. One of those books is this, Evidentiary Foundation. I promise you there will be a time in your career where the other side says objection, and they are attacking you because they say you've not laid a proper foundation or it's an inadequate predicate, and some judge who you disagree with is going to say, sustain. Can you lay a further predicate or foundation? And you try, and they object, and the judge goes, sustain. At that moment, I go, may I have a moment, Your Honor? I've done this many times. I go under the table, I come out with the book. Usually the jurors are chuckling because they know, okay, Romano's got to go look it up in a book. And I come to, let's say it's medical illustrations. And it'll go, how to lay a foundation to use a medical illustration with a medical doctor on the witness stand. Ask these 6 questions. It's that simple. I ask the question. I shut the book. They object. Overrule. Go. Get that book. It's in the 13th or 14th edition. All right. Greg Cusimano, brand new book, Seeds for Success. Not only a teaching tool, a motivational tool. There is, and finally, a brand new book that is going to be introduced, I believe, at the AAJ convention, the AMP method, Anchor, Modernize, Persuade, by the great John Lomurro out of New Jersey, who is just a whiz kid at everything that he does. And he's really into technology and AI and everything. So And there are many other books, but one thing you can do with every one of these authors that I just told you about, you can pick up a telephone. I promise you, you can do this. And you can say, my name is Hal Jenkins, and I'm a 28-year-old young lawyer from the middle of Nebraska. I'm brand new, and I just am looking for some guidance. Mr. Rowley, Mr. Friedman, Diane Weaver, Lisa Blue, Aaron Deshaw, can you talk to me for a few minutes about an issue I've got in the case? I promise you, they will either talk to you right then or go get back to you. What I like to do is Zoom calls at night. I say, I can't do it right now, but I can do it tonight at 9 o'clock, and that's what we do. I just saw Jessica there. Jessica, do you need to make an announcement?
Nope, sorry. Zoom just crashed, so I'm back.
Okay, okay. Are we good? We're still going?
Yeah, we're still going.
You guys still keep
Okay,
going. You're all good.
okay. Just a few more minutes and then I'll stop. But I want to mention one thing about your continuing legal education. There is no question, and Aaron was talking about it before, what we do at our Workhorse seminar in Florida. And we do it every either February or March. It varies from year to year. And we go 5 days from 7 in the morning until 10 o'clock at night. And it is truly, people are there who are just on fire to become great lawyers and to work magic for their clients. When you are thinking about a seminar, always be thinking about not just the overall theme of the seminar, but who are the speakers? How real are the speakers? I'll come back to that in a minute. Then number two, how relevant are the topics to your practice and what you need to learn? And then number three, how is this going to help my client? Not how's it going to help me, not how's it going to help my law firm. How is it going to help my client? Okay. Now let me go back. In around 1978 or 9, I actually went to a seminar in the Midwest. It was a one-day seminar, and it was called The Trial of a Medical Malpractice Case. The very first speaker, who was really a fun, entertaining person, spoke on jury selection in a medical malpractice case. And about 3/4 of the way in, he goes, you know, what I'm talking to you about today applies in all of our cases. For example, I've never tried a medical malpractice case. I almost fell out of my chair. How in the world can you talk about jury selection in a med mal case to med mal lawyers? Now, pay attention to the speakers. Make sure they are genuinely equipped to discuss the topics you or some senior partner is paying for you to go to. And that second thing, be thinking client, client, client. And I say this wherever I go, you have 3 agendas in every case. Number 1 is the agenda of your client. Number 2 is the agenda of your client. Number 3 is the agenda of your client. So, Aaron, those are some quick thoughts on books, seminars, and what we're doing. And I turn it back to you, and we're ready to go.
Thank you. I mean, that last
switch.
point is the last point is actually a very interesting one because at Trial Guides, I I did something and I went after the authors that really knew the topic well and were
Yes.
successful, and not necessarily the most popular speakers. And it's interesting that you say that, because if you're going to model yourself after success, you need to know who it is that actually has the experience doing it.
Yeah, I mean, it's so important, and I know I keep mentioning it, but if you take somebody like take Nick Rowley, take Keith Mitnik, take Karen Kohler up in Seattle, who's in trial right now. I'm sure you know when she's in trial, she does these daily diaries that are about 10 paragraphs of what's happening throughout the day. And I find it remarkable that she can even do that.
Yeah.
But when those three lawyers say, consider doing this in opening statement, I'm paying attention because they're constantly in the courtroom. They are constantly winning in the court. And by winning, I mean they're doing remarkable things. We're not going to win every trial. I'm sorry, those who are listening. It's not going to happen. But you can still be a winning lawyer, even if you don't prevail in a case. I look back on one case that I tried, a med-mal case. I thought it might have been the best lawyering I ever did. And there was a defense verdict. Okay? It still hurts. I still think about that case all these years. But a real key is, yeah, you want people who are doing it, who have that experience. If I'm going to have heart surgery, I do not want a podiatrist. I do not want an orthopedic surgeon she might be the greatest orthopedic surgeon in the world. No, 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 no. I don't want that. I want a heart surgeon. So,
Mhm. So, hey, I want to jump back to sort of, your primary talk there about the different books and so forth. And things have changed a lot, particularly since 2020. And now we've got this sort of, never-ending stream of podcasts and webinars and things like that. And the newer generation, I think, is maybe under the impression that they can learn a sufficient amount by listening to things like even this webinar between you and I. And I just wondered what your thoughts were about, what's the difference between a podcast and reading the book?
wow. Well, I'm a believer in not only the books, but the podcast. I like the podcast. I like the books. I like the webinars. We learn from all of them. But I want to tell you something that happened to me just last week, last Tuesday. I went up to Jacksonville, Florida for an in-person summary judgment motion hearing. The judge said, I want everybody there in person. When the hearing was over, the main defense lawyer brought an associate with him who is just a great young man. And he said some nice things to me right after the hearing. And he said, Mr. Romano, I've been practicing law now for 8 months, and this was great because this is my first hearing at a courthouse. And I said, I am sorry that that's happening because the Zoom hearings they're wonderful. I love doing Zoom hearings because a typical hearing takes minutes, not hours. On the other hand, when it's more like a summary judgment motion, Dogger hearings, the ultimate final pretrial conference, those kind of things, I prefer that we do those in person. But Aaron, let me go back to the very beginning of the case. Lawyers still need to bond with the opponent. I have said this forever. I do not look upon defense lawyers as my enemy. I've never done that. I look upon them as an ally, and we're going to have disagreements at times. I refuse to I won't let it happen. I never let it get personal, ever. The reason is the agenda of the client. As soon as it becomes personal and ego driven, now I've set the client aside and I'm paying more attention to me. You can't do that. So what I want lawyers to do is meet each other. Don't do initial client interviews via Zoom with the thought, I may never meet this client. Meet the client. Talk to them. And in certain cases, you cannot ever bond with a client if it's just Zoom. It's a different kind of bond. We put it that way. So to me, the podcasts, the webinars, the books, we need them all. I thrive on them. If I know there's a great webinar this Thursday on something important to us, I want to try to watch it. If I can't, it's recorded. I can watch it later. Same thing with certain podcasts. There are different lawyers around the country. I'll just give you an example. If Joe Fried is doing a webinar, frankly, on any topic at all, he could be doing a webinar on what is Joe Fried's favorite movies or what are his favorite movies. I want to watch it because I'm going to learn from Joe Fried. If Randy McGinn, I'm going to learn from Randy McGinn. These are lawyers who are always going to teach me things where I go, oh my goodness, I had no idea about that. So to me, it's the combination. Get the books, read the books, follow the podcast, follow these webinars. I think they're just extraordinary learning tools. And I tell older lawyers, some of whom might be my contemporaries, I suggest to them, adapt. And don't start telling me AI is for the younger lawyers, I'm not going to pay. If you are practicing law, you have a duty and an obligation to your clients, however old you are, to pay attention to everything that's happening in your profession. And that means staying up with the case law decisions, reading the statutes, knowing what's going on in the legislature, learning AI and basics of computer technology. You don't have to be able to invent a new computer, okay? But you do need to know how to operate it, how to use AI, and how to download and how to upload. And yeah. And if you don't want to do that, get out. Because you can't practice law as a hobby. It's got to be, you are all in all the time.
Yeah, I mean, like one of the things that I find so inspiring about you is every time I'm with you, every time I see you speak, you're both incredibly passionate, but you're also like, hey, I don't care how long I've been doing this, I'm going to keep pushing myself to be better. And I think it's just it's a great thing that you bring to the profession. So, kind of along with that lines, I'm going to talk about something that might be a little bit controversial, and that is the dedication that's necessary to become great at what you do. And I wondered if you could tell us a little bit about sort of your process and how you've kind of come up through the profession and your dedication to being the best you can be.
Wow. Well, when we were talking before about John Morgan's book, Luck, my mother used to say to us when we were kids, there were 4 boys, 2 girls in my family. And she would at least say to the boys, she said it in a little different way to my sisters, but she would say to us, the greatest thing that can ever happen to a young man is to fall in love with the right person. And you're together forever. And I believe that is true. I'm also sensitive to the fact that it doesn't always work out for some people. I understand that. And I do understand that. And I feel bad when things like that happen in relationships. But there is no question that in my mind, the 2 greatest things that happened were the parents that I lucked out having, and then meeting and falling in love with my wife, Nancy. That right there, that encompasses everything, everything. Another part of that, though, is, Aaron, I was born excited. I don't know how else to say it, but I would be in a class and Sister Violetta would walk in and I was in second grade. I didn't care what she was going to say. I just couldn't wait to hear her say it. It didn't matter. I just was excited about being there with the other kids. And then years later, it was sports, and years later, college and the United States Marine Corps. Aaron, I love, this sounds crazy to most people, I loved Marine Corps boot camp. And no, it doesn't mean that I loved every second of it. But overall, it was such a positive, wonderful experience. So to me, when it comes to the practice of law, it is a mindset. It is all about your enthusiasm. How engaged are you for the claim? How enthusiastic are you in helping the judge figure things out? How intriguing do I want to appear at certain times in front of the jury, and at other times, I don't want to be intriguing at all, just open, total. So to me, it is more attitude and work ethic than anything else. And I know it's a cliche, we hear it. People will say, I don't feel like I've ever worked a day in my life. I honestly can say that and pass a polygraph exam. I don't feel like I've ever worked in my life. It's all been just wonderful. I will never retire. In one more month, I turned 77. I just told somebody 2 days ago, the way I see it, I'm halfway through my career. So I want to live to be 150. I want to do this forever. And it is wonderful when you do this and you are all a part of your family. Your family is a part of you. All the things we do as a family with children and with, we've been blessed with extraordinary daughters-in-law and with grandchildren. And it doesn't mean from time to time there are not issues that arise that have to be addressed, but to me, that's what the journey of life is about, the extraordinariness of what is happening. And yes, people will call me Pollyanna, and my response to that is, you're damn right. If the movie could be remade, I would like to star in the movie. We'll set aside Haley Mills. She got to do it the first time.
Let me ask you, what is your thought in regards to work ethic and achieving, the best that you can be as a lawyer? Is that something that you can have? And I guess the big issue is a lot of young people are looking at work-life balance, and maybe they're looking at guys like you and me and saying, "Hey, I really don't want to do that." And is there a path to greatness without putting in that kind of extraordinary effort?
I would say the answer is yes, but it's greatness for that person.
Okay.
If for example, you want to be, let's say you're a great athlete and you're a great tennis player, and you're a 15-year-old young lady and you're just terrific. You're winning a lot of tournaments and you want to win Wimbledon. There's no shortcut. You are not going to Wimbledon, and you're definitely not going to win Wimbledon unless you dedicate your life at that point in your life to winning Wimbledon. Same thing with gymnasts, same thing with football players, same thing with what you did going through the education to be a scientist and a lawyer. So a lawyer came to meet with me Oh my goodness. This is in I think August of last year. And because of some issues over the years where I've learned things from experience, I said the next time that I hire a young lawyer, I'm going to have a mission statement for that lawyer that lays out everything that is expected of you as a young lawyer if you come to work at Romano Law Group. And as circumstances developed, there were two lawyers that ended up in the interview process. Each one, I promise you, you would have been proud to have as a lawyer working at your law firm. Just extraordinary young people, smart, dedicated, and everything. And after 4 interviews with each, plus separate interviews by Eric and Todd, on a, I think it was a Tuesday, I called each one separately and I said, I'm going to send you something. And it's mission statement of an associate lawyer at Romano Law Group. I want you to read it carefully. It is not private. You can discuss it with your parents, your significant other. One was married, one was not, with your spouse. And then I want to call you back. I remember saying this Thursday night. Let's do a Zoom call. And the one said, I can do this. I am ready to do it. I want to do it. Let me jump ahead just a moment. We hired her, and she is turning out to be spectacular. The other said, at this point in my life, I could never meet these expectations. So, respectfully, I'd like to withdraw my name from consideration. What I told this young man is, I said, you know, if I were with you right now, this was a Zoom call, I would just give you a big hug and I'd keep hugging you. You have no idea how much respect I have for you for what you have just done. And I said, I have a feeling our paths are going to come together in the very near future and things will work out. And I do think that that is going to happen. But I expect a lot of a young lawyer, and more than anything else, I expect them to be unconditionally devoted to the client. And if they say, I don't have that in me, that's okay. This is just not the place for them. They might want, they would need to do something else. We give our cell phones out to all of our clients. I never thought that was a big deal. Yet I had one lawyer who we interviewed about a year ago. I would never give out my cell phone to a client. Talk to me. Why would you not do that? Well, and basically it was work is work, and my private life is my private life. I said, okay, I get that. Well, I'm not offering a job to that person. You can't. You can't. It's like a trauma surgeon saying, oh, I don't work after 5. What? I mean, people get hurt after 5. And our clients call. Sometimes they call at midnight and they're crying and they're worried that they're going to lose their home, or they just got served with some kind of paper that scares them. And it's important that we have people who are going to be totally devoted. And to me, it's always been, it's not about work-life. You know, I hear this. What is your firm's policy on work-life balance? I flat out tell them, we don't have work-life balance. We have work-life fulfillment. Because if you love what you do, you're not thinking all the time like, oh my God, when can I get out of here? Then it's a job. And I tell them, I don't want you working here if it's a job. I don't want you working here if it's a career. I want you working here if it's a calling. Because if it's a calling, we're going to go on that journey together. And it's going to be a powerful, explosive experience for all of us and our families.
Where do you think the commitment, to your clients like that comes from? Because I mean, there's a lot in the legal profession that they're not that way anymore. Let's just be honest.
I know. And it's, I can tell you where I got it from. My dad was a medical doctor, and he was a general surgeon, general practitioner, did everything. So we'd be eating dinner, the phone would ring. Get to the hospital, Mrs. Jones is in labor, she's about to go. He would tell my mom, keep everything hot. I'll hustle back off to the hospital, deliver a baby, home. And then he would have dinner whenever he got home. Then he'd get home, he'd be eating dinner, 9:30, the phone would ring. Doc, we got somebody with an emergency appendectomy. They need an appendectomy. Get back here. He'd run back to the hospital and he'd do surgery on somebody. Aaron, he always did it in such a loving way. Not once in my life, not once did I ever see him, I can't believe this, the game is starting, or the party's starting, or dinner's starting. Never. He always went, I'll be right back. And the hospital, well, down here in Florida, the hospital was about a mile from our house. When we lived in Framingham, Massachusetts, it was 1 block from our house. But as I saw that over the years, I so admired that. And I thought, that is just the coolest thing in the world, that this doctor just loves what he's doing. And I always thought, I really hope that one day, whatever I get into, it will be that. And I always thought, there were 3 things that I thought about when I was growing up that I wanted to do. I knew I wanted to be a doctor or a lawyer, and I knew I wanted to go in the Marine Corps. That was always a part of it, because several of my uncles had been in the Marines, and I really looked up to them, and they were very special people, and I thought that would be a wonderful thing. So.
Yeah. I was going to ask you, what influence do you think that your experience in the Marines had on sort of the way that you have practiced as a lawyer, if at all?
Well, it did, because, again, now we get more to luck. Again, after in the Marine Corps, if you go into JAG, your first 3 months is boot camp, regular infantry boot camp. Then they send you for 6 months after that to advanced infantry training in what is called the Officers Basic School in Quantico, Virginia. Then 3 months to Newport, Rhode Island, to the Naval Justice School. So you're on active duty 1 year before you get to practice law. And I had said I would like to be assigned to felony cases where the action is really happening. And I'm wherever that is. And I was sent to Camp Lejeune, North Carolina. And it turned out to be a remarkable experience. So I get there. The guy who is the equivalent of the, I guess what we would call the district attorney, okay? It's not exactly the equivalent, but close enough. Colonel Bailey, he's out of Boston. It was like God dropped him into my life. That's how wonderful Colonel Bailey was. And he was the head of all the prosecutors, all of defense work. Then the guy who becomes the head of I was in defense initially. When I was moved to prosecution, who drops in? Jack B. Zimmerman. Jack Zimmerman was a Naval Academy grad, a Vietnam War hero. He comes to Camp Lejeune. He ends up my boss, and then in life becomes one of our greatest friends. Our kids great friends, our wives, great friends. Jack actually left the Marine Corps to go to work with Racehorse Haynes, the famed criminal defense lawyer in Houston, Texas.
Mm-hmm.
So again, it's luck, running into all these wonderful people. And to me, part of the biggest thing in the Marine Corps is no matter what the task is, you can do it. Example, they don't ask that you be some kind of a physical stud who can lift 1,000 pounds over your head. What they do say, though, is you need to climb that 20-foot rope within the next 3 weeks without using your legs. And the first time, most people you pull up maybe 1 or 2 poles, and you can't go anymore. And then, before you know it, everybody's going right up the rope. The obstacle course, the runs, the hand-to-hand combat, all of those kind of things, you learn that. And so what I try to teach lawyers in our law firm is there's nothing you can't do. And don't think you've got to be like somebody else. So you don't have to be like the Lincoln Lawyer. You know, we're watching that series now. It's great. You don't have to be like that. Don't compare yourself to others. You know, there's a saying, comparison is the thief of joy. And I think of it, I've heard somebody say this, but it's so true. A flower never compares itself to other flowers. It just blooms. That's what we have to do in life. We just bloom. So to me, the Marine Corps teaches us how to bloom. Sometimes by yourself, but almost all the time blooming as a team. And that's what makes it so wonderful.
So I wanted to, I actually had this noted, but you just brought him up. Racehorse Haynes, who was he for
Yes.
the younger of the audience, and what impact did he have on you?
Oh, goodness. So his name was Richard Racehorse Haynes out of Houston, Texas. And he was, if you go back to the 60s, the 70s, the 80s, one of the famed criminal defense lawyers of our time. There was a case where the wife of the Speaker of the House in Texas was accused of murdering her husband by shooting him in the back of the head. And he represented her, and there was an acquittal. And then he did a lot of murder cases and represented a lot of famous people who did naughty things they shouldn't have been doing and got in trouble with the law. And he had an extraordinary string of victories. He was a great personality. So when he would be on like the Johnny Carson show, they would have him on there. He was funny, and the host would be laughing. He was engaging, but he was a totally devoted trial advocate. And I had the privilege one time of being able to sit in the back of the courtroom for about 4 hours and watch him in a murder trial. And all of the fancy stuff, the funniness, the joking and all that, there was none of that. He was a humble, laid-back, soft-spoken lawyer who just exuded credibility in the courtroom. And I thought it was just a remarkable thing to see. But he was legendary out there in Texas, and Texas has had a lot of legendary lawyers over the year. I would tell young lawyers now, though, look, you can get on CVN, Courtroom View Network, and all these lawyers that we're talking about, at least modern day lawyers, say the last approximately 20 years, you can watch them. I mentioned Nick Rowley, um, Karen Kohler, Lisa Blue, Mark Lanier, Diane Weaver. I mean, I could go on and on. They're all on Courtroom View Network. You can't, for the most part, you cannot watch them pick a jury because they don't. Um, Most judges will not allow any cameras to be on when during jury selection. But you can watch them give opening statements, conduct direct and cross, give final arguments, and it is an extraordinary teaching tool. Another great thing about CVN is if you have an expert in a case that the other side is using, you can watch what that expert did in another case, or you can watch your opposing counsel, how he or she did, how they behaved, how they argued. It's extraordinary. It's a great recon tool, so you can figure out what you're about to face.
So I wanted to bring up another legendary trial lawyer, Al Cohn. What was your relationship with that gentleman?
Well, Al J. Cohn, I did have the honor of trying two cases with him, but when I came out of the Marine Corps, I went with his firm. And Al had been a former president of AAJ, then APLA, back in around 1965. And Al was the founder of the Florida Justice Association, which was then called the Academy of Florida Trial Lawyers. He would tell you that in his life, and more importantly, he was a major in the United States Army and landed in Normandy on D-Day. And he was a true war hero, combat veteran who spent several years in Europe in World War II. So merely to be in his presence for me was like just beyond a wonderful experience. But what Al was all about was not himself. It was about everybody else. It's like every day he got up and all he thought about was, what can I do to help everybody else in the law firm? He was so respectful to the receptions. He was so respectful to every, and then we called them secretaries. Now it would be legal assistants and paralegals. He treated young associates like he was the associate and you were the senior partner. I would go into his office and he'd say, can you stay a minute? Let me get you some coffee. I go, Mr. Cohn, it's okay. Let me get you some coffee. And he knew how I like my coffee. He'd go fix my coffee. He was that kind of a guy. So I got to see him, and that was his way. He was a magnificent teacher at the seminars. His verdicts down in Florida were legendary. But what I've got from him was he was such a tender, caring, loving person. And he it's like he embraced everybody. And you would see him in trial, and no matter what they would do to him, he would not get riled up. He wouldn't get upset. And other lawyers, I remember he was trying a case with one of the other partners in the firm when I was a young lawyer there, and the other lawyer was just beside himself and wanted to challenge one of the other lawyers. He said, let's take it outside. And I watched Al just simmer them all down, and it was really good. But he was a brilliant guy, a great lawyer, a great leader, and we have a number of awards in Florida which are named after Al Cohn, and he's really just everything about him was a great memory.
Oh, thank you. Hey, I we've got a couple questions, so I want to pose them to you, and I'm going to ask this.
Sure.
And I'm not even sure how we're going to deal with this one because it's pretty broad. But what is your technique for getting a jury to award large damage verdicts?
Ooh, well,
I'm gonna interrupt you real quick here. Back in I think in the 70s, Mo Levine answered this question. He said, "You know, the best way to get $1 million verdict is to have a $4 million case." Um, but I'm going to let you take that one and then see where we go with this.
Well, I have some good news for everybody. There is nothing more important in your practice in terms of the direction it will go, more so than case selection. When I have a good case with good facts and a deserving client, I will get a good verdict. It's not about lawyering skills. It's them. It's good facts and a good client. And what you do is you are trying to help bring their message to the judge and jury. But don't think of yourself as a magician, like it's all me. I see receivers in college and professional football. So the coach calls the play. The fans are all supportive. The linemen are all blocking. The running back blocks the defensive end. The quarterback takes several steps back, and he lofts the ball right in the arms of the receiver. The receiver gets into the end zone and looks up at the crowd and goes like this, beating his chest, me. And I go, no. How about turn around and thank everybody who was a part of making that play work? Thank them all. And don't bring the attention to yourself. And I know that we get hyped up in sports. It's happened to all of us. I get that. But to me, in trial, when I hear a lawyer say, I did this, and I won, I go, whoa. What about the client? When you talk to jurors afterwards, I don't know, but I have never had a jury tell me, oh, I liked how you did this, and I liked how you did that. Well, we believe this witness. We didn't like her. Your client didn't do so hot, but your expert was great. And what your lawyering is about, probably 95% of it, is everything you do before you get to the courthouse. So working to make sure that you present good facts, and you can take facts and you mold them ethically so that when you present them, they are good facts, solid and strong facts. And do what you can to do the same thing in the way you mold your client as a witness. I had one case 2 years ago, we mock tried it over and over again. And we were not only losing, there were unanimous verdicts against us every time. And we made a decision with the clients on board. We're not going to even get to first base with the jury in this case. And we were able to settle that. Well, it doesn't always happen. Sometimes you do the mock trials, you lose them all, and the other side says, we're not paying a penny. And then what you do is you go in and do everything that you can to do your best. Remember this, there was a great battle, November of 1912. The battlefield was in Memphis, a land we now think of as upstate New York. And the battle was against the U.S. Army and Native American Indians, whose fathers and grandfathers fought each other for a century, killing one another. But on this day, battlefield will be a football field. You see, Army, favored by 8 touchdowns, was playing the Indian school in Southwest Pennsylvania known as Carlisle. The captain of the football team for Army, the heavily favored team, and the team that had big guys, athletes, well-fed, well-trained, were going against the smaller school where they were all skinny, but they were led by someone very special, who you all who are listening know as Jim Thorpe, thought by many to be the greatest athlete that ever lived. And at halftime, it was Army 6, Carlisle 0. And then Jim Thorpe went wild in the second half. The final score was Army 6, Carlisle 27. Carlisle believed that even though they were smaller and not as well trained, that they were shifty and fast and could cleverly do things that Army would never figure out. And that's what happened. Do you know who the coach was of that little Indian school in Carlisle? You all know him. His name was Pop Warner. He invented the forward pass. Some will say, well, he didn't invent the forward pass. It was invented a few years before that. No. The forward pass was first invented. It was thrown like a shot put. Pop Warner changed it and said, why not have the quarterback put his hands on the treads and make it spin, which became known as the spiral. That day, they ran a play that nobody had ever heard of, in addition to the forward pass. It was something called the double reverse. Army didn't even know what to do with it. And Jim Thorpe scored and scored and scored. When you take the impossible case in, you got to think like Carlisle and Pop Warner thought. It's against the odds, but we can do it. We can't do it by just running into them head on. We got to be more clever. That's a big insurance company. They got millions of dollars to fight us. We got to outsmart them. We got to out-tactic them. We got to out-strategy them.
It's, actually that plays right into another question I had for you, and I'm just going to throw out some stats. Insurance Research Council says that 98% of all tort claims settle before the case is ever filed. And, you look at the U.S. Department of Justice Bureau of Statistics, and they'll say that another 98% of the ones filed don't get all the way through to verdict. And so I kind of want to ask you, we even see, I think, this moving further towards the settle everything route. And I just wondered, what are your thoughts about that? And how does that end up impacting case value for the clients?
Well, our firm is no different from others in this respect. I would say 96, 97% of cases do settle. But to get maximum value on most cases, but especially on bigger cases, the catastrophic injury case, a wrongful death case, unless there are low limits and they're going to, like a $100,000 policy in its death case, that's different. They got to know that the plaintiff lawyer tries cases. They got to know that the plaintiff lawyer wins cases. And they got to know that your law firm has the people and the money wherewithal to do it, and that you got the stomach for it. That's why most people don't want to do med mal or products cases. You got to have the stomach for it to do those cases. Okay? I'll take, for example, an auto case, and I'll say to a driver, you agree that you were reckless. Well, the driver, they're scared to death. Yes, I was reckless. I've never had a doctor say that in a med mal case. You agreed, doctor, you were reckless when you cut off the wrong foot. How dare you suggest such a thing? It's a different world, med mal and products. So when I look at that, I just go, you want to get maximum value, you got to get to the courtroom. You got to try cases, you got to win cases. Now, I had a lawyer say to me, well, isn't the really important thing that they know you'll try the case? No, they got to know that you try the cases and you have the ability to win the cases and that you've done that. Or somebody on your team who's going to be lead counsel. I'm not saying everybody who does PI work needs to be a trial lawyer. Some of the greatest personal injury lawyers I know do not try any cases, but they know that at a point, they must involve a lawyer in the case who will go to trial. Okay? That's what's really, really important.
I want to move to another question here. If there was not enough to do as a new lawyer and you keep asking for more work but don't get much, would you consider reading these books during the day at work as an impressive attribute of your new hire, or would you see the person who is constantly concerned with asking for work as more important? Do you, and then this person follows up, do your new hires read these books at home or during downtime at work? I love reading and learning and am not in love with asking for work every day. Anyway.
Well, theoretically, if I am doing my job, this is how I look at it. There should be no downtime at work for a young lawyer. I'm 76. I have zero downtime. Nancy and I have lunch together every day. It takes 15 minutes. I pretty much have the same thing because I've found over the years, lunch just destroys the afternoon. And there are exceptions to that. But I mean, all the books that we give our young lawyers, they are reading them at home, at night, on the weekends. There is so much to be done on cases in the daytime. Communicating with clients, responding to discovery, thinking up new discovery, thinking up strategies, preparing for depositions. I've got a deposition that I will be taking a particular witness the week of August 16, 17, right in there. And I do my own outlines. I've already done a draft of the outline, and that deposition is several months away. What that allows me to do, whether it's my regular time or downtime, is think about it. And I might be driving down the highway and I'll think, oh, there's another thing I'm going to want to add to that section on causation or whatever the issue may be. So you want to do those things early. But if the question is, the books that we are talking about, when would you read them? To get the most out of that, for me personally, I would be reading them at night or on the weekend. But I would see nothing wrong with reading them in the daytime. That is a part of your work, your overall plan. And you may say, well, look, what I'd prefer to do is I want to read this book, 3 chapters at this time today. And I'm going to fiddle with written discovery on the case tonight between 9 and 10 o'clock, or whatever it might be. And Aaron, over the years, so that people will know, I made it to all the kids' events. I made it. I made it. I was able to coach the kids. I would go to the PTA meetings. I would go to the teacher meetings when the teacher called and wanted to see mom and dad. All the vacations, the ski trip, we did. You can do it all, but to do it, you're maneuvering things to make it happen. It won't happen by itself.
Yeah. Okay. There's another question here. Ideas on what you would say as an icebreaker in voir dire. And then it says, don't like any of the first things other lawyers say and am not satisfied with what I've been saying. Just doesn't seem to connect or be authentic. Do you have any ideas?
I do. About 25 years ago, I was getting ready to pick a jury in Fort Myers, Florida. And I had a trial consultant, Harvey A. Moore, PhD, sociologist, fabulous trial consultant. And he said, how are you going to start off next week in jury selection? And I said something to this effect. I'm going to welcome them to jury duty, and I'm going to thank them for their service as jurors. And he goes, stop. Why are you going to waste their time? Why are you going to make them all of a sudden not believe anything you say? Because they're going to immediately react and say, this guy's total BS. Don't do it. Plow right into the first question. I said, well, what might the first question be? Well, you're the lawyer. Okay. So I put together a voir dire outline, and I forget what it was now, but let's just say it was, I don't know. How many of you have served on a jury before? If that's your first question, that's fine. How many of you have served on a jury before? If it's a pain and suffering question, is there anybody in here who doesn't believe in pain and suffering? So let me tell you where I ended up. In that particular trial, here's how I started off. Folks, I didn't come back and introduce myself or say my name or talk about the purpose of what here. I said, folks, how many of you, and I'd like to see you raise your hand, please. How many of you, when you hear that somebody's been in a rear-end collision, then you hear that person complains of a neck injury, how many of you have as your first reaction, I'll bet they're faking it to make a buck? May I see a show of hands? He warned me. He said, every hand, Johnny, is going to go up. And then you're going to say, I used to feel the same way. And then you're going to start. Anyway, the answer to the question is, don't start off thanking them for jury service. Don't start off with what you think might be some clever, cute little saying or joke, or bet you were, it was just the greatest day in your life, the day you got the jury summons. You will get laughs from that. You will. But they'll think you're total BS. And it depends on who you are. Some people I know are naturally, they're gifted. They are really just funny people. And they can do that. Most of us are not that way. So think about that. Get to it. They don't want to be thanked. They don't want to be hailed as heroes because they're here for jury service. They want you to get to the point. By the way, post-COVID, we got to get to the point a lot sooner, a lot quicker, and it better be a point. Because a lot of them were going, what is the point of this 4-hour cross-examination?
Yeah, I agree with that. John, are you doing okay for time? Because I've got a bunch more that I want to go through, but I want to be respectful of your time.
I am. Can you give me one moment to check
Yep.
on something? Because my senior litigation paralegal has been, she has a series of darts in her hands over here, and I want to see what the darts are for. I'm back. I'm happy to tell you that what was just handed to me by Sally plays into something that we discussed earlier.
All right.
But a client of mine in a TBI case where there's a brain injury and a spinal injury with surgery, an issue has arisen that is important, and they need to talk to me tonight. And I just told Sally, you just, whatever time they can do it. So they're going to come back. I suggested to her 9 o'clock would work. But that goes back to what Aaron, you and I were discussing before. These things come up. She's had surgery, and now she's seeing a doctor, and the doctor wants her to go through certain other procedures, including another surgery. She's terrified. And who does she want to talk to? Her lawyer.
Yeah.
Not because her lawyer's a doctor, but because her lawyer will listen. I heard Joey Lowe from California speak recently, and it was beautiful. His talk was just beautiful. But he said, "You want to be a better lawyer? You want to be a better person?" And then in his Joey Lowe style with the cowboy hat and all that, he goes, "Listen." And I could hear the echo of Jerry Spence in the background. Listen. Jerry used to say that. And that's it. We got to listen to our client. There's a saying, your client is your greatest co-counsel. There's a lot to that.
All right. I have a couple more questions here. How about what would you say in a jurisdiction where the voir dire you question one person at a time? What do you say after good morning?
Wow. I did a criminal case in about 1983 or 84 in Connecticut. And when jury selection was explained to me, that judge was we were going to ask each juror, it was one at a time. I don't know what other states do that, but Connecticut did, at least back then. And I remember thinking, how on earth are we going to get through all of these jurors? And voir dire just took a long time. But what it meant was we were going to have extreme, strict discipline and limit the number of questions. And it's a great question. What would the start-off question be? All I can say is I don't know what it would be right now because it would depend upon the kind of case, who's the judge, the timing, who's the client, a lot of that. I can only say this. I would make it I wouldn't be thanking this juror for jury service. I wouldn't do any of that nonsense. I would go right into a meaningful question where the answer tells me this may or may not be a juror we want to keep. That's what I would want to find out. I would want to have, I like always having a trial consultant. I'm a big believer in having a trial consultant assist with jury selection. And remember this, I told you about Dr. Harvey Moore. He's now retired. But in a given year, it would be a big, big year if I had, this is like in the 2000s and after. But if I had 3 trials or 4 in 1 year, that's a big trial year. Back in the 70s and 80s, it was different. You would try 8 to 10 in a year. Dr. Moore would be in the courtroom sometimes for 45 days of jury selection.
Yeah.
So who's the greatest expert on jury selection? He lives in the courtroom for jury selection.
Yeah.
So I would have someone, if it were in a state like Connecticut, who's familiar with that system, but I would go right into meaningful questions. I would not dance. The last time I explained to a jury the purpose of an opening statement, I think I was probably 30 years old and never did it again. Okay? And I'm not saying I wouldn't do it in the future. There could be a reason. But generally, no. You got limited time. You want to get to the meat and potatoes of it.
Yeah. I mean, I think that it sort of underscores the importance of looking at some of the books by our trial consultants, both that we publish and other people publish as well. I think Lexis and maybe AAJ have a few things,
Yeah.
but the David Ball on damages and the Eric Oliver books and Hirschhorn's books and Lisa Blue. I mean, these are people that are sitting through a lot of trials and they're sitting through like large loss trials. And I got to say, one thing that I've learned the hard way is it seems like every time I forget to mention something that David Ball has in damages, the jury comes back and returns a verdict that if I had just asked that one more question, I would, have a better
Yes.
outcome. And it's just like you just can't miss anything in there
Yeah.
because he's nailed down
Oh,
exactly
yeah.
what it is.
Yeah. Well, and
Um,
on the prior question, Aaron, about getting the big damages award, at least in a state like Florida where we can mention an amount,
yeah.
I had discussed the amount in jury selection. And I discussed it again in opening. And then in different ways, subtle ways, they're going to hear about it throughout the trial. And then we'll discuss it in summation. But in jury selection, a question that I might routinely ask is something like this. It would be at the close of the evidence, we may ask for a verdict in an amount not to exceed $49 million. When you hear that number, are you saying in your own mind, I don't care what the evidence is. I will never go there, not me, no way, not going to happen. I always have the person go, I didn't quite follow that. And I slowly repeat the question. And then I go through it with each of the jurors. But I want to get that out. Now, half the time, the defense lawyers object. And then we go up to the bench. And I say, Judge, there's no case law, zero case law in Florida that says that's not permissible. And Judge, when she gets up here and she starts her questions for the defense, she's going to say, if you find the evidence is in favor of the defense, can you come back into the courtroom, look at them in the eye, and tell them they get zero? I said, she gets to say, we want a verdict for zero. I want to say whatever my amount is. So to me, massage it. If you wait till summation to start talking about money, you get sticker shock from jurors.
Yeah.
Some way, even in states where you're not allowed to say a specific amount, there are ways the lawyers in those states have of communicating amounts to the jury. Your economist says the medical bills are this amount and the wages are this amount. And then you get up and say on pain and suffering, those amounts that you heard from the economist, they're peanuts. You can use the word peanuts, but that's nothing compared to these pain, suffering, anguish, scarring, disfigurement, etc. So you're making somewhat of a comparison. They get the message.
I'm going to read you a question and then I'm going to have to, I got to plug in here real quick, but I think I'd like to have us both answer this one because we've got great experience in dealing with these cases. So the question is from Christopher Heavens, and he's asking, if you have a client who suffered a TBI and looks like there's nothing outwardly wrong with her, would you consider not having them attend trial except for introduction to the jury? In my case, the client had a drug addicted problem and addiction problem, excuse me, I misread that, and was in jail and overdosed and stopped breathing, suffering brain damage. We are suing the State Division of Corrections in a 1983 action. How do you explain to the jury why your client will not be sitting through trial with them?
Okay. Let me say to Chris, there are three parts to this. Part 3 will take me about a half an hour. Call me. Call me this week. Here's my phone number. It's my cell, 561-346-5090. The answer to the question, do you consider not having the client there? Yes. That is a definite yes. I've done that before. In a more recent trial, a great lawyer from Melbourne, Florida named Doug Bean tried a TBI case. The best way for me to describe it was that his client looked perfect. She was a real estate saleswoman who she looked perfect. Okay, I'll leave it at that. They made a decision after doing mock trials, to never bring her to the courthouse, to not introduce her to the jury. Okay. They got a report from a doctor, an affidavit, and the doctor said the worst thing in the world for this TBI patient will be to go through the stressful, pressure cooked, intimidating situation at a courthouse. And worse than that is for her to sit and have other people talking about how bad her brain injury is. They showed the affidavit to the judge and said, Judge, she is not going to be here. And the judge says, that's your call. The defense lawyer said, I'll make this short, but the defense lawyer said, fine, we're going to call her. So nobody says anything. Plaintiff never brings her to the courthouse, explains to the jury about the affidavit, which the judge let him do. And in the defense case, the judge says, who's your first witness? And they said, we're going to call the plaintiff. And Doug said words to this effect: do you have her under subpoena? Because we're not producing her. They did not have her under subpoena. And in the end, the judge's decision was, you didn't subpoena her. She doesn't have to be here. And she never testified. And in a concussion case, they got a $4.8 million verdict. So the answer is yes. In certain circumstances, I consider that. Let me take it another step real quick. I don't ever have a client sit with me at counsel table, ever. If it's a death case, like a child and the parents are there, I explain to the jury, we're going to have them sit behind our table in the back row. But from time to time, they're going to need to go outside because of what testimony is going to be coming up next. And I said, for example, when the medical examiner testifies, they will not be in the courtroom. And I just want you all to know, we want them back there so that they can get in and out of the courtroom. The trial that I did in 2025 with the neck surgery, I told the jury she will be here in the courtroom, but she has to get up constantly. So instead of having her at counsel table, we're going to have her sit on cushioned seats in the back row. Everybody was okay with that. So yes, I consider doing things like that in every case.
So I do about 90 to 95% TBI cases in my practice. And I just tell you, I have not had a client in with me during the majority trial for a long, long time. The one time I reconsidered that and had the client sit in, I regretted it. The outcome was not nearly as good as it should have been. And I think that in general, the jury looks at the client with a mild, what's considered a mild TBI medically, and they're just going to think that there's nothing wrong with them and give them nothing. I think the big reason I don't have my clients in, though, is because I don't want them to hear what other people have to say about them, particularly like a spouse or people that are close in their life, where it could destroy their relationship. Because like even when I'm preparing witnesses, which I'm preparing people right now, I say, they have the right to get my notes if they want them, but I'm going to tell my clients, you don't want the notes that I'm doing, to prepare these witnesses, because I'm telling them I want to hear everything, the good, the bad, the ugly about them since the TBI. And not only that, but the client won't be sitting in trial. So the witnesses, the lay witnesses already know that they can say whatever they need to say to the jury about the whole truth about what happened with the client. And some of it's not pretty. I mean, even with a mild TBI where you can't see anything and there's no positive imaging, it definitely changes people. And you got to keep in mind, for those of you that don't do TBI cases, 80% of all TBI cases are going to have negative imaging. And so you're going in I mean, really the best you're going to get is maybe some neurology and your neuropsychology or something like that that's going to say that they're injured. But the lay witnesses are going to come in and they're going to say, yeah, this person's like nothing like they used to be, and here's all the reasons why, right? I wanted to actually address this issue about the drug addiction problem as well. I think there's a really helpful thing that you should be considering in this case, and that is look at the Mo Levine book, which is, yeah, right there, right there. The Mo Levine book, and also the uh, Bill Barton Recovering for Psychological Injuries book. There's a method really in both of those books that I refer to as qualitative damages. And that is somebody who maybe didn't start out with the best life, but whose life has now been changed for the worse, and they have very little. And so the concept is it's not what they're left with, it's what you took away from them, and now sort of their end state. And maybe that doesn't make sense, but I think that a lot of us think about damages only in terms of quantitative. In other words, we're saying, hey, somebody was at a 10 out of 10 before, and now they're at a 4 out of 10. And, the non-economic damages needs to be this 10 to 4 range or whatever. But this concept, and Mo Levine talked about it in this case, it was two homeless people, and the wife died. It's kind of a famous case from the 70s, and I think it was one of the first $1 million verdicts in the United States. But he basically said, this man had very little to begin with. He was homeless, he was an alcoholic, but the only thing he had in life effectively was this wife that took care of him and loved him despite his shortcomings. And now the tortfeasor took her away from him, and they got a big verdict for this gentleman. And so I think that one of the ideas with a case like this is Nick Rowley's brutal honesty. Go in and just say, this person had a lot of problems. They were incarcerated, they had drug problems, etc. And unfortunately, what the state took away from them was the only thing they had left. It's just an idea. What do you think about that, John?
I like that, and I love his entire concept with brutal honesty. It is so important. If the jurors sense that you, as the plaintiff lawyer, are trying to dance around an issue, you will pay for it. They will
Yep.
punish you.
Yeah. Credibility on the plaintiff side is key. And I've seen some of this mentioned in a couple of our books that they anticipate the defense will lie and they won't penalize them. But if we do anything, even if we make a mistake, they're going to shove it down our throats. And you got to be very careful about being credible in every possible way. So I'm going to jump back to some of the questions I had for you. What do you think about the argument that some of the younger lawyers are having, or even some mid-career lawyers, that they can't get to trial anymore? What do you think about that concept, and how could you maybe get that to change with the clients?
All right, you ready?
Yep.
I don't buy it. Let me tell you why. Let me tell you why. Lawyers that want to go to trial, you can go to trial. I remember Simon and Garfunkel, maybe it was just Art Simon, came out with a song once called 50 Ways to Leave Your Lover. And it's really a funny kind of a song. But I once did a speech called 50 Ways Plaintiff Attorneys Talk Themselves Out of Going to Trial. And there are more than 50 ways. We have a lawyer named Bob Joyce in Tampa. Over 600 verdicts. He goes to trial on average a dozen times a year. Although I recognize the business model is different. And you can't, it's like comparing apples to oranges. But I spoke to one of the Morgan & Morgan attorneys in Miami recently. In 2025, he went to verdict 29 times. Okay? They have a team. It's like 3 lawyers, and they were doing Miami, Lauderdale, Palm Beach. Okay. There's another lawyer. I'm drawing a blank on his name right now, but he's down in Miami, and he is averaging 20 trials a year. What happens is we set a demand. Let's just say you've got a case and you feel it's worth $1 million. And you say to the client, they've only offered 250. Client says, I want to go to trial. And you say, well, we're going to go to trial. Then what occurs is you still are coming down a little. They're coming up a little. And they get to 750. And you say, that's way insufficient for this case. So the trial lawyer says to the client, we need to go to trial. We got a good case. I feel confident about it, etc. Let's go. By the way, it's the concept. Try the good cases, not the bad ones. Don't let them force us into that position. Then this occurs. A family member calls me, hey, our long lost relatives are coming into town and they're going to be here all weekend. And you go, I'm going to miss all the family fun because I'm going to have to work all weekend because I got this trial. And then you start going through all of the reasons in your mind why the case should now not be tried. And then you tell the client, who will do anything you want. Almost all the time, almost all of our clients will do whatever we suggest. They just will. We know that. But the lawyer who doesn't want to go to trial starts lobbying the client. Maybe we shouldn't go to trial. And then says, we shouldn't go to trial. That's what I'm going to tell my partners, because the client wants to settle it now. All I'm saying is, lawyers who want to try 10 cases a year, you can try 10 cases a year. I truly believe that. And if you don't want to try cases, you're going to come up with every reason on God's green earth to not go to trial. And is it wise to settle cases? Of course it is. In Florida, the case that we tried in Lauderdale, 1 year to get from the post-trial motions to the record on appeal delivered to the appellate court. And now the briefs. So by the time there's a decision, it will probably be at least a year and a half post-verdict. And you say, well, yeah, but then you get paid. Well, then we get paid if we win the appeal. And if we don't. So what people do is go, oh my God, if we go to trial, we still won't get paid for a long time. Are there exceptions? Yes. If I've got a case just recently settled, we represent a woman who is 82. And we knew that she was failing. And I told everybody, there is no option. We must get it settled. By the way, in Florida, in a Mandell case, if there's no surviving spouse and the person is elderly, no more case. It's over. So we settle that.
For those of you who don't follow claims practice, insurance claims practice stuff, it's important to note that we are all tracked by federal tax ID number. And if you settle every case, the insurers know that because they're keeping stats on all of us. There's third-party AI apps now. Insurers are actually using those to determine who they're going to use as a defense counsel against us. And so, if you have a reputation for settling everything, you're just not going to be getting very good values on your cases. And That's just one reason. Either you got to litigate yourself, or you got to bring in trial counsel like John to try cases with you or for you. So that's an important point. I think we need to keep in mind. Um, let's see here. Oh, I know. I was going to ask you kind of a follow-up on that question, which is, don't you think that part of the reason why your clients are willing to go to trial with you, though, is the relationship that you've established with them over the period of time that you've represented them before you get to that point where there has to be a decision between settle for whatever the insurer has offered you versus, hey, let's file this thing and go to trial.
Yes, the relationship of trust is paramount. I had this goes back a little ways in history, but I had a lawyer who I was working with on a case, and the case was assigned to this person. And I said, "Did you meet with her yet?" "No." "When were you going to meet with her?" "Well, we talk once in a while on the phone." I go, "That's not the question. When were you going to meet with her?" Now, here's the shocker. This client isn't like in New York or Portland. This client is in Delray Beach, Florida, which is neighbors to West Palm Beach. It's 20 minutes to go to her house or to have her come in here. I do believe in the personal meetings.
Mm-hmm.
I've got a case, Aaron, in Portland. It's a trucking case. I'm coming out the last 2 days in May to Portland to meet with the client. People say, "Hold on, you're going to fly across, you've already got them signed up. You're working with your co-counsel. You're going to fly across the country." Yes, that's exactly what I'm going to do. That's the reason I'm going to Portland, to meet with clients. Couldn't you accomplish everything by just doing a Zoom? Everything except the personal touch. Yeah, I can say, "What's your name?" and get an answer, or "Where'd you go to school?" or whatever it is I might want to ask. But the personal touch, to see them, to feel them, to give them a hug, to where they look in my eye, I look in it. That to me is so vital.
Yeah. I mean, I came in late on a trial last year, was brought in by George Sideropoulos out there in West Virginia into a double amputation case. And I flew in multiple times for focus groups and a variety of other things.
Oh
And,
yeah, yeah.
went out to the house. And I got to tell you, some of our interactions, even though it was much less than I would normally have with the client because they were out of state, I think it was everything. And in fact, the client and I had a conversation the morning of his testimony that I think really changed and allowed him to sort of break through and have this personal disclosure to the jury that frankly I don't think we would have gotten out of him if I hadn't spent some time with him and gotten him familiar and comfortable with me. So super important. Anyway, um, you've been practicing, I think, is it 52 or 53 years at this point?
52 years as of, let's see here, May 10th.
All right. And I've heard you talk a little bit about competing forces of hope and fear. Does the fear ever really go away, even though you've been practicing this long?
Uh, no, it doesn't. To me, fear is it's a good thing to have so long as it's um, controlled and you're aware of it and you know what it means. But I let people know, Nancy and I love the movies. We love going to the movies. Always have. And we were watching the movie Hunger Games, the first one. And there's a scene where the bad guy, who's the head of everything, he says to his assistant, he's talking to him about fear. And he says, is there anything stronger than fear? And the assistant says, I don't know. And he says, hope. Hope is stronger than fear. I need you to take away their hope. I nudge Nancy. I say, yeah. She goes, shh, shh. I said, no, I got it. She goes, no, tell me afterwards. Tell me after. I'm thinking about it the whole movie. And I'm thinking, all right, it's 1957, Aaron. And Dad is 32 years old. Mom is 32. And they go down to the beach at 2:00 in the morning with their 10-year-old daughter, their 7-year-old son. And they're dressed in regular clothes. And it's windy and raining. And they have a huge inner tube. And they float it out a little ways. And Dad ties every member of his family onto the inner tube, and he finally ties himself on. And they're fastened in. And they push and they go out and they start floating out to sea. They were escaping Cuba in 1957. The fear was sharks, drowning, cold weather. Maybe we don't float to Florida. Maybe we go off to somewhere where they didn't even know about. But the hope of a new life, of freedom, was so overpowering, it crushed fear. And I told Nancy after the movie, I had a trial coming up. That's the new theme. Hope over fear. And it did. It became the theme that we had in a major case. And I've often thought that's what so many of our cases are about. Hope over fear. And the jurors come into the courtroom, fear, hope. Think about this. When the jurors are brought in, they're at a place where they don't want to be, and they're not allowed to escape until some authoritative person says, you now have permission to escape. So they're captives in a place they don't want to be. And we have to be thinking about that. Most, I don't know, but there are very few who say, yeah, I'd love to go spend 3 weeks in a jury trial.
Yeah.
I think it does happen to be that once some of them get there, they do start to really get into it.
Yeah, I want to go back to the hope and fear thing. I think probably the first time I read about this was again in David Ball on damages. This concept that you have to give the jury something positive to do, and it's very difficult to do that if you point to or you paint too bleak of a picture and don't provide the jury with some hope that what they're doing is going to help the client. You have any thoughts about that?
Oh, you're framing it as giving hope to the client.
Well, yeah, I mean, I think that the jury needs to know that the client's going to try to keep overcoming, and that whatever they do in terms of their verdict is going to be helpful to the client in carrying forward in a positive
Yeah,
way.
yes, it's vital. It's essential. And then and again, I'm going to go to. I chalk this up to luck, but an example of that happened in a trial where I was representing a paraplegic, and he's testifying. And when I'm done with my question, the defense lawyer said, when you came to the courthouse, did you drive your special van? Yes. And it's equipped with, etc., all the things you need. Yes. I have no idea why he would have done this. This defense lawyer says, and sir, presumably you were able to find one of the handicap parking spaces right up near the ramp. And he goes, well, first of all, he got really torqued at him right in front of the jury. I don't think of myself as handicapped. I refuse one of those handicap stickers. And the answer is no, sir. I didn't park near the courthouse. Wherever I go, whenever I go, I park as far away in the parking lot as I can so that I can get more exercise, because I don't have and I don't want an electric wheelchair. I want to wheel myself. And I remember how that reinforced what he had said on direct exam about self-help. To me, that is important. Jurors want to know what's going to happen with the money they might award. Is it going to be wasted? Is it a client who is likely to try, in that case, his best to do good? We've had some cases where you have a child who is brain injured and paralyzed, and you're in trial. I'm making this up right now, imagine this. And there are 15 family members and new friends of the family sitting in the courtroom. And each one has a little sign on his or her head that says, waiting for my tape. Just picture that image. I think jurors look at that and go, all these people want to do is get at his money.
Yeah.
Because he's horribly brain injured, disabled even more than that because of the spinal injuries. Can't do anything, can't think, can't talk, can't walk. So what's all this money going for? Because the doctors have said rehabilitation is important, but not so much to get him better. The rehab is to keep him alive. Mm-hmm. And if the jury thinks, yeah, all these people are just looking to make a buck, that hurts. It hurts.
Yeah. Actually, I want to jump off of that thought right there. What are your thoughts about loss of consortium claims? I mean, do you think that that's something that is it something that you do often? Or are you of the thought that like maybe the jury's going to look at that and say, hey, in a catastrophic case, maybe that partner is going to jump and take whatever money they get and leave? I mean, does that worry you at all?
It does worry me, but I'm a mega believer in loss of consortium claims. Spousal, parental loss of consortium, filial loss of consortium. In one TBI case that I tried, the jury, a concussion case, okay? A concussion and then arguably some level of dystonia to the injured client.
Yeah.
In that case, they awarded the wife $10 million on the consortium claim.
Wow.
The wife was the driver of the aura of the case. She was the case, not him. Not him. In another case that I did in Salt Lake City, it was a brain injury case, but a severe brain injury. Young boy had been in a coma for like 2 months, and then little by little was getting better, but not a full recovery. And when Eric and I did the case, when we filed the complaint, we included a loss of filial consortium claim, meaning a claim where we were seeking pain and suffering damages for the mother and father over the injury to their son. Somebody told us that's going nowhere because in Utah, filial loss consortium is not allowed. But we read the decision of the Supreme Court. It involved a 45-year-old man, so an adult son. Okay, so we filed. The judge who dismissed it says, I sympathize with the plaintiff. And I believe that in Utah, we should have filial lawsuit consortium when it's a serious injury, permanent injury, and the child's a minor. Well, in Utah, unlike in Florida, you have to appeal that right away. You don't wait till the end of the case. The rest of the case keeps moving on. So we did appeal it. And roughly 8 months later, we had an appellate firm out there. The Utah Supreme Court, in a 5-0 unanimous decision, rules, we hereby adopt filial lawsuit consortium in those cases where there has been a serious, permanent, debilitating injury to a child who is a minor at the time of the injury. And they adopted filial. It made a huge difference. That case did ultimately settle. But suddenly now, a mom and dad who became caretakers, everything about their grief and their anguish is now full front and center. And remember, in TBI cases, at least some of them, we try them like they're a death case, a wrongful death case, and we use a grief and bereavement expert. We've done that in various TBI cases. So I'm a big believer in the consortium case, and I tell people don't worry if there have been marital issues. The jurors are mature. They understand that sometimes there are issues that occur in a marriage, and don't let that frighten you away and say, well, they had separated twice before this happened. Therefore, let's not bring a consortium. No. They're together now. They went through counseling. The counseling worked. The consortium claim will be good.
Okay. So on your list of books that you named earlier on, you named both Sach Oliver's book on deposition and also Mark Kosieradzki's 30B6 book. And I wanted to ask you, what do you feel like the value of depositions are, and could you give the audience some pointers in terms of how you use depositions in your cases?
The best way of putting it is if somebody said, describe your life as a trial lawyer, I would say, well, most of my life as a trial lawyer was a life as a deposition lawyer. Okay. As go the depositions, so goes the result in the case, either by settlement or verdict. What happens in the depositions wins or loses the case, or it drives a big damages settlement or not going to be so big damages settlement. Which is why when we prepare our client for a depo, it can't be 20 minutes of just do your best and tell the truth. That's not preparing somebody at all. It takes hours, and we need to arm them with vocabulary, words to use, and everything. Sach Oliver is right, and Kosieradzki believes this. Mark believes this. You must prepare for depositions just as you would be preparing for testimony for trial. And I'm a big believer in that. And it means you have to start way, way early. If you have take a trucking case, the second you get a call from a client, somebody was injured or killed in a trucking case, click. You know that if you get in that case, at some point you need to take the deposition of the law enforcement officer, the truck driver, the immediate supervisor, the director of safety, and others. And then you'll take 30B6 then. Now, in Oregon, no expert depots, so
Right.
you won't be doing that. But you'll be doing all those other depositions. And the key is, if you handle, let's just say you handle in a 3-year period 10 trucking cases. 9 will probably settle, 1 will go to trial. The one that goes to trial, let's just say it takes 2 weeks. But in the 10 cases, if you add up the deposition time, you will have spent 3 months in deposition. The deposition are equally important to trial. And that's why they've got to be looked at and thought about as every bit as important as going to trial. It is a huge event. If you are a lawyer in a law firm and you find somebody bouncing down the hallway one day, hey, anybody got a deposition of an accident reconstruction engineer? When's the depo? Tomorrow. My suggestion would be walk out and counsel that lawyer so that that never happens again. If it happens again, that lawyer needs to go because that lawyer's heart is not in it. You can't get ready for a deposition of an important witness the afternoon or night before. You have to have thought about it and been thinking, well, what if they go this way? What if they go that way? And I've had people say, well, they can't. I've got the document and they signed it and they agree to this. I go, forget the document. Sometimes it says that on the document and they say, well, that was an error. May I explain? I was under pressure. The most important person in my life died 12 minutes before I signed that. Now you got to deal with that. So you got to prepare for the, what if they go here? What if they go here? What if they go here? All of those ways. It's like a strategy in the military. Okay, it's great. Let's surround them. But what if we surround them, but they've got a tunnel and they get away by, okay, you got to think about it. Maybe they got a tunnel. And that's what we got to do as lawyers. We got to think about the tunnel.
Yeah. Yeah. I mean, I gotta say, we just had an example of that where this case I was involved with Michael Leeserman, a great trucking lawyer. He came in and looked at the police report, did a deposition, and the driver discloses that he lied to the police and that, the facts weren't anything like what the police report said. And it just materially changed the case. So, yeah.
Oh, yeah. It's huge. It's huge.
Um, So my last question here is, you've known a lot of lawyers over your 52 years of practice, and certainly we don't need to use any names, but are there things to avoid in your practice that would lead you to success and avoid failure? Any thoughts on that?
Yes. Yes, I have a thought on it. Avoid even the temptation towards complacency. Complacency is something that grabs you and it pulls you in little by little. And once you get there, you don't care. Okay? So what happens sometimes with professionals, it can happen with anybody. It can be a lifeguard, a lawyer, a police officer. The routine of doing things in and of itself can often cause somebody to be complacent or to take for granted what you have in being a lawyer. And the key is stay energized, stay excited, stay focused. And you always have to be laser focused. What is the goal for each and every step that you're taking as a lawyer? When I do my depo outlines, I was working on another one 2 days ago. What's today? Yeah, 2 days ago, Sunday. I put in the beginning of my outline, deposition mission. And I usually have about 20 items. Whatever my mission is for that deposition. Then at the very beginning, I have another section called Watch Out, Johnny. It's a self-warning where I go, be careful about asking one too many questions on this point, because he might drag something else where we don't want to go. Whatever it is, are there certain things I want to watch out for? Like if I ask a question like this, have I now waived some position we're taking on something else? So, and then I start the outline. I like to do it myself because if I'm the one asking the questions, I got to know the playbook. And I want to be the one to write out the plays, so to speak. And that's why it is so important to me to do that.
Excellent. Well, thank you so much for your time today. You got any final thoughts before we go?
No, this has been wonderful. I just tell people keep pushing. You take care of yourself health-wise and attitude-wise. Take care of your family. You do that, and you take care of your clients. All will work out for your staff and your family and your law firm.
Thanks so much, John.
Okay. Thank you, Aaron. Thank you, Jessica.